Jerks. Hopefully everything's working on the StreamYard. Some StreamYard issues nationwide today. A lot of outages lately. Hopefully everything's working because we got a big guest tonight and obviously a very big day in court, a frustrating day in court. But something came up that I think might be good. I think we just have to keep in mind this might be over very soon. And when the judge said today, the jury seems fed up. Fed up at who? Fed up at who, Bev? Fed up at who, Judge Canone? That could be the best news today. There was a lot of shit that went down today. We have a guest. Let's bring him up because if I was thinking, like, if I had to do a solo show tonight, I would probably just be swearing all night. I was so frustrated by court today. I feel like all of you are too. Some like my mods were like, "We need a night off. We can't do this tonight." Like a lot of people are like that. Let's bring up Attorney Bederow. He usually makes us feel better. I think some of us need that tonight, right? But I also think we also have to think this nightmare might be over very soon. Let's bring up Attorney Bederow and see what he thinks about Attorney Brennan today, who misled the jury. That's exactly what he did. He intentionally misled the jury, and this judge did nothing about it. Mark Bederow, what's up, man?
How are you?
Good. You must have a lot to say tonight. I'm just imagining after all this roller coaster, just what could happen next. Today was just a whopper of a day.
Yeah, today was not a good day if you watch this stuff and you want to see how trials work and function properly. A lot of people think that this proceeding is a sham. They think the DA's office is a joke. They don't trust the prosecutor. They think the judge is biased or worse, some people feel. And days like today totally feed that beast. You saw all kinds of things that are just, you shouldn't be seeing in a trial because they shouldn't be happening. And, you know, what you saw, the stunt with Brennan today was, I mean, he should just be ashamed of himself. And if his best defense is, I made an honest mistake, you can choose whether you believe it or not. But if you marshal the available evidence from both today and before today, I think that's hard to believe. That's my opinion anyway. I think it was intentional. I think he has a pattern of doing this in the past that you've seen with other things about implying that facts and evidence exist that are not true. And, you know, sometimes he gets called out, but, you know, not all the time, right? I mean, so if you get away with it a few times, perhaps it would have worked. And he almost did today. And in essence, he did, because they caught it later. And the proposed remedy by the judge, or I should say the administered remedy by the judge, was also embarrassing. And in that whole process, she was more upset at Bob for consulting with co-counsel than she was at Brennan for, again, what appears to be, again, in my view, unquestionably trying to sneak a fastball, you know, on the corner and get a called strike that would have, in his mind, helped substantially impeach a very important defense witness. And that was shocking that was her reaction. That was the remedy. And I hope that's certainly not the end of it. But what happened today, and that's just one example. There's a lot of examples, and we can break down why. But it's not just the holes in the shirt that he tried to imply were clearly from the car accident that he alleges happened. And if that were the case, that would have undermined a major foundation of the witness's opinion, that because there were no holes on the hoodie, that was a big deal. There was only one test in which they occurred, and it had to be from road rash, da 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 da. And He did it at the very end of his cross-examination for maximum impact. He did it with a dramatic presentation of, presenting the mounted hoodie, which maybe now we know why the hoodie was mounted. Who knows that he kept behind until the very end. And he got caught. And his defense is it was just an honest mistake. And here's the problem with that. His own witness created the holes, you know that, and it's a criminalist who testified at this trial, so presumably was prepped. Presumably they reviewed her paperwork. Do you really believe that Hank Brennan did not know that the holes on the back of the hoodie came from his own witness? I mean, do you really believe that? Does anybody seriously believe that? And that he just learned that today after this mistake? I don't think that makes a lot of sense. And this is a person that he had lined up to be a rebuttal witness as well. This is a person who testified last year for Adam Lally and his partner McLaughlin. Did they know about it? Did they sit there like potted plants and allow this to happen and not correct it? A lawyer is obligated to correct the factual material representation to the court. I mean, under the legal professional conduct rules in every jurisdiction. Did they know? Did they do nothing? And if the defense doesn't see it themselves, this never gets corrected. So you sit there and you say, how could he not know based on everything you just saw? And then you also say, why did it only come out in the recross at the very end for the big moment? He's going to stick the landing. It makes no sense. Don't forget when the hoodie came in the direct and the cross that he was doing, he said, look at the side. And it came out on redirect that there were holes all over the place. And he still sat on it. And he waited and waited. So it doesn't make any sense just on the merits of his excuse, which is, I just didn't know and I made a mistake. And he got up there for the first time in this trial. What did he look like? He looked like the cat that swallowed the canary. He was all sheepish. He didn't even defend his integrity. Okay. Bob basically called him an unethical many things. The lawyers never talk about other lawyers in court like that unless, you're really going at it. And he didn't even push back. He just suggested, why don't you tell them that I made a mistake? And then you sit there and you say, if it was an isolated incident and he had a lot of goodwill built up on this kind of stuff, that maybe you would be inclined to give him the benefit of the doubt. But then you look at the rest of his past history in this case, or at least part of it, and you say, doesn't that make it even less believable? During the trial, right, with Barros and the photograph, what did he do? He stated affirmatively, you identified a photograph in the trial, knowing that was not true, in order to get him to say it and then cross-examine him. But he put facts out that he knew were false, and he got away with it. He put in the lack of dog DNA in this case, right, which was not in evidence. And there was nothing the defense could do about that. He cross-examined Dr. Russell about the current witness, La Posada's opinion about the dog stuff. And again, the defense isn't in position to talk about the evidence. He cross-examines her on it and then has the temerity, the gall, to move to preclude that witness from talking about it in the defense case, which he did successfully, which is also, are you kidding me? But does that sound like something that was planned and maybe misleading? Pre-trial. Remember the whole ARCA production? The big 15-minute story about how there are ghosts in the hallway of the federal court, and I know how this works, and gave that 15-minute speech that he probably practiced in the mirror for the big landing, and then said, I had to get it from the feds because they suppressed the evidence, except they did give it to him. No real apology there. He accused David Yannetti of violating all these rules, going on court TV, and this is outrageous. He didn't do it. He was wrong. Again, another mistake, another accident. He accused yours truly of passing, not privileged, but protected material from client A to client B with no evidence because it didn't happen, and said I would probably do it again.
Yeah, he didn't put it in writing though. He remember he said he wasn't going to object, and then he objected.
So there is a track record, and you see how aggressive he is, and you factor that all in, and then his own preparation for this trial works against him because he's so meticulous, he's so thorough, he's so aggressive that the idea that this one just slipped through the cracks, that he didn't know that the hoodie, which is such a powerful piece of evidence that he introduced, he had Buchanan hold up and look at it and point at it. He looked at Dr. Russell about it. He looked at this. Why didn't he turn over the back of the hoodie and confront Dr. Russell and say, what are these? What are these? No, we're supposed to believe that he just made an honest mistake today, and that's his position. You can choose to believe it or not. I don't believe it.
For a second, based on all the other actions, like you said, just you can't do the same thing over and over again and pretend you're not doing it because he's doing it.
Right, but what he did today, I mean, is far and away the most egregious because he literally implied materially false facts. Now, if he did that intentionally, that's a very serious ethical violation, and that could lead to all kinds of things. Like grave concerns, things like that. Now, you didn't hear any of that today. It was just accepted as a mistake, and I don't even need to inquire further, which is regrettable given the way the judge has reacted to much less offensive grave concerns that, apparently resulted in precluding argument and all kinds of things. But the jury was given the impression that Dr. Wolf's opinion was completely undermined by all of these other holes in the back, which could have come from road rash and in this very accident, and that his opinion was entirely undermined. I mean, a key threshold of his opinion would have been undermined if the jury even accepted that. And to do it, he didn't even show the defense the evidence. Now, that's another interesting thing. This is a skilled trial lawyer, and trial lawyers always show the other side the evidence, but he just kind of grabbed the board from back there, put it in his face, and it was done, and it was over before you knew it. And it's only through the good fortune of the judge ordering a break, I think, that they figured it out and came back. And now they have these reports which clearly show that these are holes that were made by his own witness, and that 3 prosecutors sat there stone-faced, not saying a word, and they either knew or they should have known. And there has to be a severe sanction, a severe remedy here. And it's not just telling the jury that just pretend you didn't hear it and that's the end of it and it's over. And because they're calling Hartnett on their case in rebuttal, I would expect the defense to really dive in to the holes that she made in this, the reports that she prepared. You gave them to the DA, you prepped for trial, you talked about this, and really try to stick it out so they can argue in summation and point the finger and say, they're trying to fool you, which is what it appears the prosecution tried to do today. And it almost worked.
The sanctions, you mentioned sanctions. The judge did nothing today. What can the defense do or anybody do about the sanctions part of this?
They made their motion for a mistrial. I think a lot of judges would have handled that a little differently, might have thought about it more than 4 seconds, because the key issue here would be, for most judges, was this gamesmanship? And if it was, most judges at that point are looking at a very, very serious sanction. Now, he got up and said, I made a mistake, which, again, is a position. The defense position was he absolutely did it intentionally, and she didn't even entertain any fact finding to determine whether Brennan's excuse makes any sense. And when you talk about the things that we've talked about and just the common sense component of it, it's just hard to fathom that this was just an innocent mistake. Maybe it was. Who knows? We're not there, but it just doesn't feel like that. And she had no interest in adjudicating that. So she clearly wasn't going to give a mistrial. And she indicated she would give a stronger instruction. Then she got upset at the defense for conferring and said, if you don't want to talk to me, fine. I don't need to talk to you.
Yeah, that was the rudest thing I've seen so far from her, and she's done a lot of rude things. That was
unjudicious, certainly, to get upset and say, I guess you don't want to listen to me, so I'll just do it my way. And then she gave the instruction. Of course, you heard at the end, they said that was not sufficient and they'll come back. But even then, she seemed more inclined and I have a jury, just file it and we'll deal with it. This is not the kind of thing that this has to be addressed. And it has to be addressed soon because this witness is going to testify and they need to know what they can say and what they plan to do. And I would assume either way, even if they get a stronger instruction, that they're not going to let this go with just, there's no evidence of the holes on the back. I think they're going to say he tried to give you a dog and pony show and it was blatantly false. And the implication is obvious. You can't trust him. Okay. And they already have a lot of reason not to trust him, in my view. So I would think the defense is going to try to exploit this for all it's worth if they can't get a mistrial, which they're obviously not getting.
Is it possible for them to go to a third party and get sanctions against any of these people, the judge or Hank Brennan?
Well, I mean, nothing's going to happen in the middle of the trial. I mean, the sanctions would be to their case, right? So, Brennan asked for an instruction to say this was an accident. That's totally improper. It's the province of the jury to determine whether this was an accident, and it's totally fair game for the defense to argue that they tried to snooker you, okay? And that goes to the credibility of everything about this case, which just appears to get grosser and grosser by the day. I mean, everything about it just feels, when you watch these proceedings, you want to go home and take a shower.
It does. Like my mods tonight, they're here every day and night that we do shows, and they were like, we need a night off. We can't. They've had enough of it. Like a lot of people have just had enough after today. The judge said it. She said the jury seems fed up. What do you think? Okay. What do you think that's about? Do you think they're fed up at the judge, at the prosecution, at the defense, at the delays? Is that a sign of anything? Am I hopefully thinking they're fed up and they want to find Karen not guilty? What do you think? Does that mean anything?
I don't know if it means anything, but my point or criticism would be, so what? Okay, a woman here is fighting for her life, and the delays today, what were the delays today caused by? An application for a mistrial. Don't blame me for wasting the court's time because I need a mistrial because the prosecutor appears to have intentionally tried to present false and misleading evidence. Okay, if you intentionally present false and misleading evidence, you can get disbarred for that kind of behavior. Okay,
I wonder, like, will there be any disbarment? Can that happen? Like, is there any chance of that, or it's just the judge is just she rules and that's it? There's nothing going to happen to Hank Brennan, right?
Disbarment. I'm not talking in this context. I'm saying generally, if a lawyer were found in an ethical proceeding to intentionally present, false and inaccurate evidence on purpose, okay, in a murder case where, somebody goes to prison, that can be very serious. But the fact that the defense has to make that argument and take up valuable time, that's not their fault for causing juror delay. When they start making that argument and 30 seconds into it, you stop the argument and say, how long is this going to take because lunch is here? That's not the defense's fault either. When you have to do voir dires for witnesses who don't need voir dires and who could have been voir dired months ago, if the prosecution filed the timelines, we wouldn't be wasting your time. So with all due respect, that's not the defense's problem because they're zealously advocating for their client and protecting the record and doing what lawyers do. So if the jury is upset, that's unfortunate. Nobody wants that, but you don't blame the defense for that, okay? You don't, how many more witnesses do you have? How long is, I don't recall those conversations in the prosecution's case. I mean, maybe I'm wrong, but it just,
never.
So making these comments about, I shouldn't have given last Thursday off. What the hell is that all about? What does that have to do with anything? I mean, that we're here and, you're litigating a serious case. When a sidebar was requested because it related to some of these issues that the prosecution was arguing about with the doctor or the final witness, and it's sustained, I'm not giving you a sidebar, and you have to keep asking. And then she says, 1 minute, I don't want to do this. She's editorializing again. She's telling the jury the defense is wasting time. You can't do that as a judge. You're giving the appearance of bias when you do that. But the comment obviously where she said the jury's getting fed up, that was not in the presence of the jury, so they don't know. But if you were the jury, wouldn't you be upset to have to listen to all this day after day with what's going on here? The other thing the judge didn't do today, during Wolf's cross-examination, Brennan was badgering the witness. He was argumentative. He was making snide, snivelly, pissy, inappropriate comments again and again. And the judge properly sustained them, but she just said, sustain, very calmly. And the message you're sending to the lawyers is, I'm going to sustain it, but you can just keep doing it. I'm not going to do anything about it. The cat's out of the bag. They hear it. Most judges, if something inappropriate is going on in their courtroom again and again, it's like a referee in a basketball game. They're going to, if they want to send a message, they start calling it tight and let you know, don't do this. Many, many judges would say, don't do that again. Enough with the editorial. Ask the question and no more. Stop. And not every judge, by the way, would do that at the bench. Some would say, enough of that. Ask your questions and sit down. In this court, though, because they have a different process, everything is at the bench. She could have called him up there and just said, listen, cut the shit with the snivelly comments about all you're doing. Ask your questions, and if you don't have any, sit down. So she did not have a good day, clearly. And Brennan had the worst day imaginable because at this point, everybody saw what he did. And the best argument he can make is that I'm not even in command of the basic facts of the case. That's his defense. I didn't know. I thought the holes on the back of the hoodie, were legitimate from the car accident. And he's had this case for however long he's had it now. And does anybody seriously believe, again, that he had no idea in looking over that hoodie that those holes were not from the criminalist cutting it open and looking for evidence and scraping for this and doing that? I just don't think any serious person believes that, other than, people who believe, again, that Karen's guilty and, caused cancer and is the reason for global warming and all of that stuff. But if you put that kind of lunatic brigade aside, I think any honest evaluator, whatever you think of the case, would say what he did today was unconscionable. It appears to be intentional. And in any event, it was entirely inappropriate and prejudicial, and it needs to be remedied a hell of a lot further than the judge has already.
What does that remedy look like further? Like, what are they going to be asking for, you think, tomorrow morning?
Well, at this point, you're just talking about a curative charge. And license to do a few things because you're not getting a mistrial. She denied that. So the curative instruction, which basically said, disregard that conclusion. No, what the curative instruction has got to say is, you heard the prosecutor imply and ask Dr. Wolf that those holes, came from the accident, all of that is stricken. Okay. And, not say whether it, you can determine it was accidental. It's wide open. Okay. They should be given a complete license to attack the integrity of the prosecutor's conduct in front of the jury in summation. They also should be allowed to introduce those reports into evidence, present them to Maureen Hartnett, and they should be given a wide berth to just grill about when she did that, why she did that. Have you spoken to Brennan about it? You spoken to Lally, and just bring it home and let the jury should be told they can decide whether that was improper or not. Either way, you can't just be told, like, I'm advising you not to consider it. It needs to be stricken. It shouldn't happen. And they should be told emphatically, you cannot under any circumstance conclude that any of those holes came from the incident on January 29th, 2022. They did not. And the prosecution was aware of that as far back as, what was it, May of 23? That should be part of the charge, that they knew that, and then leave it to the jury to decide whether they blame them intentionally or not. But, we've talked about this many times, how the biggest asset a prosecutor has is his credibility. He wears the white hat. Well, his hat is nowhere near white. It's about as dark gray or black as it gets after that stunt today. And he sacrificed all his credibility because, the Wolf, was a good witness, and he handled him very well today, even before that. And he had nothing, his percentages were blown up, his kinetic energy argument and all that stuff. And he kept trying to stick to it. And then he started saying how much lighter a human arm is than the dummies or Randy. And then, which begs the question, how is that helping you? How is that helping you if the car is smashing into the arm and, the arm has no injuries? I mean, how does that help? So he was having a really bad time, I think, on his cross and recross, and then he screwed it up big time today. And I would expect they're gonna clobber him with Hartnett on this. They're gonna introduce these reports. They ought to be allowed to do it, and I would think they're gonna clobber this on summation as well, and call directly the integrity, not just of the state police and the competence of the Canton police, but the integrity of the prosecution itself in the summation in front of the jury, and say they tried to snooker you. And what does that tell you?
Question said, lawyer, said they should be able to write the instructions to the jury.
Well, yeah, they should prepare it, present it, and the judge ultimately has to decide. I mean, there's still a judge, but she needs to give them a wide berth on this, because the argument is they've already been prejudiced. You can't unring the bell. I mean, you can tell the jury, but the jury heard this 5-minute presentation of, this apparent bombshell, if you believe the prosecution, that the witness totally screwed up because of all these holes on the back of the hoodie.
Question about Aiden today. Paula says, what's the update with Aiden's court today? Are you able to say much about that? He's got a misdemeanor trial, right? A bench trial?
Yeah, I mean, I'm obviously not there. It's a 2-hour today and 2-hour tomorrow misdemeanor bench trial. I can't talk about the substance of it other than it's going very well. But I mean, it's a bench trial. There's no jury to influence, if you will, with public comments. But it's on trial. It's going well. This is the case over the protective order alleged violation by being in court. But I won't get into it beyond that.
Looks pretty good for Aiden on this one. I mean, definitely, I gotta say, like, it just, if you take him one by one so far, we'll see. You never know, but it looks pretty good. Everyone wants to know about this one. We keep getting this one tonight about the appeal. I don't want to hear about appeals. Studio B says, what worst case scenario? What kind of groundwork does this lay for an appeal?
This is a pretty solid appellate issue today. What happened? I mean, look, again, you have a pretty solid body of evidence that the prosecutor intentionally tried to mislead the jury by reaching a factual conclusion that would have been favorable to him when he knew it was false. And if he didn't know, he should have known. And if he didn't know and should have known, the two people sitting next to him definitely knew and or should have known. There's a lot of prejudice on that issue. And, was that mistrial worthy? It may very well have been. I think at a minimum, the judge should have inquired further and say, how could this happen? That sort of thing. And you need to give a much better, if she doesn't change the remedy, she hasn't cured the problem. I mean, just telling the jury, forget about it, don't worry about it, by having, a lawyer for the defense hold up the hoodie and not even get to point it out and do anything, and then just say whatever you heard on cross about the holes, forget it. That's not enough. So I think that's a pretty strong issue. There may be other issues. The way she is really restricting the witness who's testifying now from giving opinions, it's a low threshold to be an expert. I mean, you wouldn't know it from this case because, there are so many Daubert motions and voir dires going on that you usually don't see, by the way, in these kinds of trials, not to this level. And I mean, look, she let Russell get cross-examined about La Posada's findings on dog bites and then deprive the defense the opportunity of explaining what that evidence is. That's messed up, okay? That is really messed up. So I think those are, some pretty valid issues. Certainly the latter issue on the right to present a defense, generally a due process right. And the first issue about Brennan's apparently intentional misleading, that's a due process violation too. I mean, you have a right to a fair trial and a right not to be convicted on false and misleading evidence and argument and conduct by a prosecutor. I mean, that's, seems to be pretty basic that you should be able to get. And for all this to happen today in a case that so many people already think is corrupt, dirty, screwed up, this is rock bottom for changing that view.
Definitely. It's like I've tried not to go too far there, but it seems like you can't help it. You can't help but think that.
Well, you can't help but think it, but then you take a step back and you say, what is the evidence here? And like scientifically, and you say, the prosecution literally does not have any medical evidence to support their case. I mean, they had the medical examiner perform the autopsy who was against them. Really, I'm talking in a legal sense. I can't even give you a manner of death. Doesn't look like a car accident. I can't exclude dog bites. And, there's no broken bones. So she was a disaster for them. They called a neurologist who said, well, we think it's consistent, with smacking down on hard surface like the ground. But that really doesn't give him that much either because there are other injuries he couldn't account for. He also said it was a flat injury. Well, what did La Posada say? Who, by the way, as you can see, in terms of medical examiners and evaluating injuries, is about as credentialed as it gets, just based upon her background. And she said there was a ridge and a pattern that's not a flat thud. It's a different kind of surface, which could be stairs. It could be an object that's not entirely like a thud. So, and they have nothing to contradict this doctor who just testified. They don't have any evidence to contradict dog bites, the prosecution. They don't have a single expert who has said that the arm injuries would not be different, that there ought to be, you would expect broken bones. They have nobody to really challenge that. I think they had Welcher say, well, I had a case one time where it didn't happen, but I mean, really? They don't have anyone to really contradict what Wolf and presumably what Rentschler are going to say, because Welcher didn't do any of these real experiments. And they come after Wolf and they're saying you're not using, the proper scientific method and this and that. And, nobody does it this way. And then what do you get on redirect? Well, one person did it that way, Welcher. And that's what Wolf is doing. He's checking his work. That's why he did it the way he did it. He's trying to follow what he did. So where is the evidence that they have that's going to establish that any of this happened?
I feel good. That's why I feel good that maybe this will be over in a week. You talked about the doctor today. The judge ruled she could testify on certain things, and you mentioned on the dog bites that they're not letting that testimony in. Is that, tell us, that seems very wrong. I'm sure you feel it's wrong, but also, is there anything that the defense can do to rectify that situation? Is there like a jury instruction they can ask for that one too?
No, that's a legal ruling, and if she doesn't talk about it, she doesn't talk about it. They might.
Brennan attacked that though with the other witness, So is there nothing they can do to bring that back?
Well, I think what they need to do is address that with the judge and say we have a problem here. Okay. Today is June 9th. Okay. Prior to filing a motion, he confronted Dr. Russell on Dr. La Posada's dog bite analysis. After Russell is off the stand, I'm now moving to preclude this witness from talking about it so that there's no pushback. That is sketchy. That's really sketchy, and they ought to revisit that and say fundamental fairness, due process. There's even an argument he opened the door to this, even if, and she is qualified. She's done a million of these. And yeah, she can't remember every this or that, and she's not published and doesn't keep it on her resume because look at her. She's a chief medical examiner. She doesn't run around advertising her services to say, I'm a specialist in dog bites. I understand them. I've seen them, but it's not a cottage industry for me. So they ought to probably try to revisit that. If she doesn't allow it, she doesn't allow it. They'll have the issue. But this expert's going to talk about the lack of hypothermia and the cause of death. And, she already got out really, I think, another huge part of her opinion, which is that there is a ridge and a pattern injury in the back of the head that is not consistent with a flat whack, which would be the lawn, by the way.
That's what I can't get over. That's what the back of the head. That's a couple things that just I could not get over. It's like you cannot explain that back of the head.
And the eye.
There's no way. Yeah.
Now every single medical witness who's testified, which I guess is Scorty Bello, the first other Dr. Wolf, as we call him, Isaac Wolf, and La Posada. So 3 that have addressed this. I don't know if Dr. Russell talked about this or not. I don't remember. But all of the other medical witnesses have said that there are eye injuries or face injuries that would not have come from splatting your head on the back and as a rebound or contre coup or any of that kind of stuff. So where'd that come from? There had to be more than just falling down and splatting. But she's also saying in so many words that doesn't appear to be the case because, unless they're going to, there's no argument or suggestion there was something in the lawn that could have caused that. They're not alleging it happened at the fire hydrant. They've abandoned the trooper Paul, hit the curb and bounced 20 feet, onto the lawn. So they're kind of stuck with what they have, and it's getting systemically dismantled after each defense witness.
Tomorrow, we expecting the doctor to be done, and then we're going to have Dr. Rentschler from ARCA.
I think so.
He's the final witness. What's he going to testify about? What do you think, how's that going to go?
The arm.
What's Brennan going to try to do to discredit him?
Well, what he always does, tell everyone he welcomes their testimony and is really happy to do it. And then the day before they testify, file a motion and try to strike their testimony or at least neuter it, because that's what he does. You've never in your life seen or ever will see again a prosecutor who spends more time fighting like hell to block the defense from doing anything that might actually provide exculpatory or favorable evidence to the defense. He's like the defender of the realm. He's not a prosecutor. He's just doing anything to not let them argue why she's not guilty. And Rentschler is potentially going to be much more devastating than even Dr. Wolf, because he's the one, Dr. Wolf's talking about more of the car. He's going to talk about the arm. And he's going to talk about, kinetics and, the movement of all this and all that stuff. And, you saw what he testified the first time. He's going to tell you, I expect severe damage in an arm getting hit. And here comes all the physics formulas and all that. And he's virtually unimpeachable for another reason, much more difficult than Dr. Wolf, because any idiot watching can understand that if a car gets smashed, or a car that's 6,000 pounds smashes into my arm, it's going to leave a mark, And I'm not talking about cuts. I'm talking about it's going to leave a mark. It's going to break bones. It's going to bruise, tear ligaments, all that stuff. And I don't think you need to be a doctor to recognize that you might get something. All right. And what are they going to counter that with? A guy who put paint on and kind of moved into a car at 2 miles an hour. He has nothing to say about this. He can't talk about these issues. Look what he did. He's going to be remembered by the jury as the finger painter who dressed up like John O'Keefe.
All I think about the finger paint, the shoulder paint.
Yeah, how
could
you
roll around? Remember those people that did the experimental drop painting, and then they roll around? That's what it reminded me of, Jackson Pollock or some shit, Jackson Pollock. I hope I'm saying that artist right. And the Smurfs. It's like a collaboration. So weird.
Yeah.
People are noting that Brennan has already filed the motion to limit the testimony, just like you're saying. He's attacking his education, methodology, qualifications. He's asking for slides to be removed. He's already doing it. It's just,
he sacrificed a lot of credibility today, and a judge ought to recognize that too. When he's arguing like hell to keep this out, don't allow this. And then he tried to pull that stunt he did today. There comes a point where you say, this guy's already been qualified in this court. He testified last year. He works at a very reputable company. He testifies about this stuff all the time. He's testifying. So let's just cut the shit and cross-examine him. And, look, we get it. Your case, it's not very good. But the answer is not to prove your case by preventing the other side from trying to poke holes in it. I mean, that's kind of how a trial is supposed to work. They're allowed to argue. They're allowed to present witnesses that are qualified. You've seen some of the experts that he's tried to get in that, he may not end up calling some of these people, but you have a tough sell saying, that Rentschler of all the experts is not one who ought to be testifying. That's ridiculous.
Clearly. There's some questions about some of the other expert witnesses that the defense aren't bringing out. Garrett Wing. We all expected Garrett Wing, the dog canine guy. Why do you think he's not?
I don't know.
Witness?
I think I don't know. I mean, obviously there's a lot of witnesses and this happens all the time. Parties make witness lists and don't call everyone. I mean, that's totally normal. I mean, I think there are some witnesses, we've talked about it before, that they're not calling. That is a little surprising to a lot of people. I don't know that he's necessary. I mean, I'm not saying they shouldn't, but, there's always a risk reward analysis. And, how much do I gain given that the prosecution has not really done anything with the defense arguments that, not that they are dog bites, they could be. Again, they don't have to, that's the big deal. They just have to be possibly. And, Russell is virtually unimpeached on this, and apparently is not going to be impeached because they're not going to do anything about it. So it may be that it's not worth adding that next layer versus he gets cross-examined. He's not a medical doctor, And do they want to really keep their argument about attacking the prosecution experts who they believe are not qualified and not potentially not do what Brennan does? Like, for example, when Brennan goes after Dr. Wolf about taking a test twice, okay, that's fair cross-examination. There's nothing wrong with that. I just don't know that I'm digging in, emphasizing, arguing you may not be credible when you have Burgess and his 17-year odyssey of misrepresentations about his academic credentials and bits and bytes. I just don't know that I would do that. Things like that. So I don't think Wing is a necessary witness.
Makes sense that they already have her, the doctor Russell is so much more on a, just a higher level, like medical doctor. So that makes sense actually. Also, why put yourself through Garrett Wing? Hank Brennan's going to attack him. Also, look, as a lawyer, you want jurors to remember and primacy and recency and all that. Exactly.
If you think you have a point proven, you don't need to muddy it up with excess gunk and just more time. And if, especially as a defense lawyer, if you can do everything you want to do in 5 minutes and you can also do it in an hour, do it in 5 minutes.
Yeah. Like light in life too, in general. Yep. Like if you can do just as quality work in 5 minutes in an hour, do it in 5. Right. Get it done. Everyone likes that. The jury likes it. The judge likes it. Here's a question. Transcripts Baby says, Dr. Wolf said twice there were cuts before Brennan held up the sweatshirt. Wolf said it wasn't from road rash, and Brennan said it wasn't my question. All calculated and intentional. Going back to that.
Yes. And to me, the closest comparison, admittedly, it was before trial and it's not talking to a jury, which is much worse. But the ARCA story he told for 15 minutes about how difficult it was to get this and how we had to, yank teeth from the feds and the defense didn't do this and they did turn it all over. And he went through that speech and you sit there and you say, how could he not know? He has to know. Everything he did today related to his examination about the hoodie, I think would suggest to most reasonable people he knew exactly what he's doing. He didn't anticipate any pushback, and he didn't get it. There was no pushback. It came after. And they just, for whatever reason, the light went on. Somebody looked at it, got the reports, and they said, holy crap, this is crazy. It's a terrible, terrible look for Brennan, because you either conclude that he did it intentionally, which is outrageous, or, he made an honest mistake, which is hard. I mean, mistakes happen, of course. Lawyers make mistakes all the time. It's just hard to fathom that you could make a mistake, a factual mistake, about such a critical issue in the case, particularly when you tried to land it in such extreme fashion and nobody at your table or anybody said a goddamn word about it. And if Alessi doesn't come back in and alert it to the court's attention, the damage is done. I mean, this is really unseemly. I just don't know how you could get to finding it's not intentional. And that's not to say that, again, lawyers don't make mistakes. It does happen all the time. I mean, every trial, I guarantee you, I would make 10 mistakes. Every lawyer makes whatever. Things happen because trials move fast. This wasn't moving fast. This was planned, deliberate, methodical, and the very end of the, stick the landing on the recross and get out of there.
I've had a good question. Why did Alessi argue that motion and not Jackson, since he was the one asking questions? Why do you think?
Don't know. Probably, believe it or not, even though Bob was pretty fired up, probably better that he did it because, Alan is in the trenches right then and there, and maybe too fired up. I don't know. Bob's kind of been the law guy, if you will, for the trial when it comes to these kinds of motions and whatnot. So, maybe just by default, you've done this once, do it again. I mean, it really, that seemed normal to me. That seemed what I would have expected based on how this case has gone and who does what.
There's a lot of clips going around social media right now about this. A lot of comments tonight came in. JM said, did anyone else see Bev talking into her hand? Did you see any of those weird?
So I saw a clip, and I get real hesitant to get into this kind of stuff. I did see a clip of what appeared to be, talking, and then seeing a camera, and then kind of doing this, but without the full context on a 5-second clip. She's not talking to Brennan. Come on, let's. I don't know what she's doing. It looks funny for internet stuff, but I'm sorry. I don't think she's speaking in code with Brennan covering her mouth and tapping in Morse code to him at the table. What to do or say? I can't
go there. We have enough to deal with. We have enough that's just outrageous right in front of us. That's indisputable. So we don't need to worry about the crazy stuff. I think that's the best way to look at it. Moto 88 says this is just kind of reiterating what we've already talked about tonight. But I think it's good that we're hearing from some of the other big YouTube lawyers. Here's Vinny. Vinny says. Jackson can use this Brennan stunt as a key point in the closing about Brennan and the entire Commonwealth hiding the truth from them and saying their experts stuck to the truth. You agree with all that, right, Mark?
I think I pretty much said that 30 minutes ago. Yeah, no, I totally agree. And I think as I said, I think the word I used was exploit this. This is in many ways a gift if you're going to be stuck, the trial's not getting dismissed. And in summation, they should go to town. I mean, look, I think the jury already probably has credibility issues with a lot of prosecution witnesses, and frankly, Brennan himself, given the strategy in the case, his demeanor, the way he's treated certain witnesses, and this is the worst. Today is the absolute worst. They don't know it yet. That's the interesting thing. If you leave this alone, the jury doesn't know how bad this really is. All the jury knows today is, wow, he was cross-examining him about the holes, but the judge said, okay, they're not, so forget it. That's fine, But your whole case is that they're dirty. The cops are dirty. They're not honest. They framed her. They planted taillight. They did all these things. Now you have an opportunity to link the prosecutor in the courtroom, and you say, I mean, the way you say it is, you see a stunt like that, it's not even just about our expert told the truth, and that's fine. But you say, look, this happened. And you say, they're not trying to fool me. They're not trying to fool Miss Reed. You look at the jury, you say, he's trying to fool you. Okay? That stunt is designed to mislead you. And you have to ask yourself, how could this even happen? And that leads into the segue that they had paperwork from 2023 talking about this. She testified at trial, never brought it out. And we're supposed to believe that that was just, nobody knew. And now you're forcing Brennan to address this in his summation, because you have to address, you have to. And now you're also forcing him to waste time on something he probably doesn't want to talk about. And you're forcing him to basically say, well, I didn't do it on purpose. I just, I made an honest mistake. Now you got to be careful too, because he can't testify. He can't vouch for his own integrity and say, I'm honest. So it gets dicey for him, but he has to basically say that was just a mistake. And he's getting defensive. He's not a likable person. His charisma in the courtroom, and will it be sincere? I don't know. But now you have him thinking about his own neck rather than, how I'm going to prove to you. And you might have seen this today. The Tough Guy Act was a lot less after this today. He got shook. His apology was very sheepish. On any other day when they talk about
shocking.
Any other day when they talk about ethics, do you think he wouldn't be pointing back and say they can say this and they can say that? Not today. Today was, I'm going to take my medicine and just give him a curative instruction. Leave me alone.
Was different.
Mm-hmm.
For the first time to hear him say, like, oh yeah, I made a mistake. This is how we should fix it. I was like, what? What? You're admitting it.
Well, he's admitting it because he has to.
Yeah.
There's no defense on the merits. I mean, there's a funny old line that a lot of prosecutors used to say about whenever a defendant would testify, and in assessing his credibility, they would say, they deny what they can and admit what they must. Okay, with Brennan today, he got stuck in that. There's no plausible deniability because Bob boxed him in with the reports. So he assessed the situation, and his only play was to jump on the grenade and say, oh, it was a mistake. Now that's not in his nature.
Oh, never. I've never seen that so far.
He got caught today with, deny what you can, but you got to admit what you must. And the only thing he wouldn't admit is whether he did it on purpose. But his position is I didn't. So that's his position. He's entitled to it. But I don't think that squares with most of the evidence, both from today and the historical record of the case.
Question about when it was happening from the Dallas Shutter Company says, why, when Brennan was questioning Dr. Wolf, did Mr. Jackson not object to that line of questioning? What would that have stopped him from putting that thought in the juror's head about the holes?
I'm going to assume they didn't know. There's no reason to let this happen and come back and then make a stink about it. I mean, if you know about it, you're going to scream and yell in real time and stop it and certainly redirect on it. The only conclusion I can reach is he didn't know. There's nothing to gain strategically from letting the jury hear that and then you having to come back and say, can you tell them that's wrong? You're better off cutting it off in advance, and the jury never even processes it. So that's not a tactical move. They missed it. It happens. It does happen. They weren't thinking about it. And I mean, I'm not sure why they would, because all you've ever heard in this case for the last 2 years, nobody ever talks about the hoodie except the right sleeve and the 9 holes. No one has ever at any time in the case made a stink about the other holes. No one has ever confronted Dr. Russell. What about these holes? Are these dog? He wanted to save it for Dr. Wolf because, contrary to what he said throughout the pretrial and trial, how much he welcomes ARCA, he's scared shitless of ARCA because they're destroying and dismantling the case.
Absolutely. I mean, that testimony, if you listen to it, if you actually watch it, it's over. I mean, it should be over. No doubts. There's so many things that they made statements that don't match the evidence. So
yeah, no, they have no unimpeachable, credible evidence to establish that there was an impact in the manner that they alleged at the time that they alleged, which caused those injuries and death and left those 47 pieces of taillight scattered all over the place, but no other real damage to the car. I mean, we got into this the other day, you know, the other problems with the diffusers and the this and the that. I mean, you could go on and on. There's nothing compelling. And these people who are hyper-focused on, yeah, but I saw a video of an exploding taillight, need to get up earlier, wake up, smell the coffee, pay attention, have a second cup of coffee. It makes you sharper. Trust me, it does. I'm at my best with 2 cups of coffee in the morning, first thing. It's all downhill from there. And rewatch it to what they said. And you'll see that the fact that some taillight eventually, broke on impact is not proof that their theory is correct. There's a reason why this guy keeps saying none of this is consistent with what the DA is alleging happened.
There was a dishonesty too that they run with that, knowing what the test actually showed, So it's just like they're so hoping the jury gets confused is basically it. That's what they're saying. They're basically saying this confused the jury, and that's what we're hoping. We're hoping the jury's confused. That's basically what they're trying to run with, those idiots on the other side.
Some people are dishonest. Some people are just intellectually simple and
That's true. Some of them are simple.
They just get it. Or they
and that's what the dishonest are hoping for, is that the jury is simple.
But I'm saying even some people who are saying, oh my God, there's a video. I mean, look, I've seen videos of people analyzing, some more educated than others. You say, that's it. Why would they do that? Why would nobody, at the defense table, oh my God, how can they allow this? And I'm sitting there saying, you're really not watching.
They're not listening. They're not listening. They're not watching. They're not listening. It's true.
Nuance, but that requires that you pay attention, obviously, and it puts the burden on the defense lawyer in summation to drive it home and explain it, obviously.
This is a good question I want to ask tonight. To show that we are fair. Tiff, I'm not sure which side she's on. It doesn't really matter. I like the question. It says, Mark, can you explain the difference between ARCA adding to their report, the new Commonwealth motion today, and Commonwealth experts changing their reports in times? It's basically the pot calling the kettle black, right?
Well, I mean, they hired Welcher to do analysis, and before trial, the prosecution experts, the defense experts analyze the prosecution experts. That happens every day at every trial. Now, the goalposts have been moved, right? I mean, according to the prosecutor, an expert can change their opinion whenever they want based on more data. More data is good. The Aperture people changed all their reports in the middle of trial. They moved the goalpost. And, if there's a reason why the defense wants to do more tests to counter that, that's where we are with this stuff. So, look, none of this is normal, to be honest with you. Nothing about this case is normal. In every case I've ever seen, there are discovery deadlines, there are expert disclosure rules, reports get exchanged. Yes, you go back to your expert and they want to analyze the other expert, and everybody does that. And then you know what happens? You go to trial, but at some point, everybody stops and doesn't just start changing things. And none of this would have happened if the Aperture guy didn't claim, again, if you believe any of this, that's up to you, that, one day in the middle of trial, I made a determination because I was just, for shits and giggles, crunching numbers, that everything was wrong. And the goalpost moved. And from that point on, and if that's how it's going to be, that's where we are.
This is Lindsay 902. She says, question, can you please ask if the defense can put forward an interlocutory appeal for misconduct of the prosecutor and judge?
That's not going to happen. I mean, I know Massachusetts has all these really strange rules for mid-trial or interlocutory appeals and whatnot that certainly in most other states you can't. I mean, like, for example, in New York, you make a record, you get a ruling, you're stuck with it, and if you appeal, it comes after. I don't think, again, I'll defer to an expert on Massachusetts procedure. They're not stopping the trial over this. I mean, she made a ruling, it's preserved. They're going to probably get a stronger curative instruction. I would be shocked if the judge did not, just based upon, because, she got upset that, Bob and Alan were talking instead of looking at her. I mean, that's not a reason to not give the proper instruction. I'm sure that'll get fixed.
This one, P. St. Croix says, if there is a hung jury in mistrial, how soon could they file a motion to recuse? Would file at the following status hearing or let things settle?
They could file it, and I would, by the way. I mean, I don't think there'll be a third trial, but if there is, the very first motion, I wouldn't have done it after this trial, the first trial. If it happens again, and legal issues aside about double jeopardy and retrials and all that, I would file a motion to recuse based upon the appearance of bias, not actual bias, the appearance, and cite all kinds of statistics about when there were daubered hearings for who and why, and the discrepancy about objections in this, the discrepancy about, not hearing motions as time was running out. I mean, you'd have to make a laundry list, but at this point, you've convinced me that without question, there is an appearance of bias that I think for all concerned, and most importantly for the integrity of the criminal justice system, which is really, the integrity only exists if the public believes there's integrity. It isn't. That's why conflicts and bias are appearances, not whether it's true. You can't function properly if everybody thinks it's no good. And the reality is, too many people believe that there is a finger on the scales of justice on this case, and it's not healthy, whether it's actual or not. And I would think that's a motion that would be made if there was a third trial, but I don't think there'll be a third trial.
There was a new witness today, this private detective that none of us really knew anything about. And then it kind of they got broken up, and I think there was either a break or a lunch period in between. But it seemed very simple. I'm just wondering if I missed anything, because I was walking some dogs at that point while watching. It seemed like he was just there for the measurements to show how far it was to the door. Is that all he was there for? What was all that about, you think, today?
Well, he did the measurements, and I think he got in the basement, or not the basement, the garage. And there are some ridges and stairs, and I think also Didn't La Posada testify that she, as part of what she looked at, didn't she look at some pictures from there? So I think they wanted to go deeper. I think they wanted to admit all these pictures from the garage, which she didn't allow, at least not for now.
Yeah, why didn't she allow that? Because that was what was interesting, right? Would she?
She should have. I mean, there's no reason not to. Their theory is that John O'Keefe went somewhere in the house. They're alleging it may be the garage. They are suggesting that might account for the temperature of the phone issues. And there are some ridges in there and angles, which maybe something happened in there. Now, they might have a stronger argument if they called Higgins and said a guy came in the house. I don't want to go down that rabbit hole. But I don't think there's any reason to keep those pictures out. But she did.
Banana 9 says, should the defense have brought up how Wolf's wife and family were harassed all weekend? Which they clearly were. Yeah.
No. I mean, the reality is Dr. Wolf was calm, cool, collected, effective. No, I mean, keep your eye on the ball.
Right. Sucks that it's a prosecutor that riled all that up.
Yeah.
So I guess what do you expect for the rest of the week here? It's going to be looks like Rentschler tomorrow, and then so that's Tuesday. Who knows how long that will last? I'm guessing probably all day with those two witnesses. What are you expecting? What do you think the schedule is going to be like for the rest of the week in terms of? I'm just wondering when we might get a verdict.
Well, I guess this doctor will be on for another hour or so on direct. Get crossed for an hour or so. Rentschler, I think, will be several hours total. So assume that gets you through tomorrow. The defense presumably could rest tomorrow. Wednesday, they'd start their rebuttal case, which is what? Welcher, the dog DNA issues, which should have come in earlier, but we're past that argument. Who else are they calling at this point? So maybe that takes a day. I mean, probably.
Yeah, I heard Hartnett too, yeah.
Right? So probably you'll sum up Friday or Monday, right? I'm guessing
Yeah.
And then jury would get the case early next week, and that's it.
Good question for you. They want to see Lola and Winnie tonight, and they also want to know what your statue of a cat is behind you.
Oh, that thing is
a golden cat. What is that?
Oh, that's
Halloween thing.
Oh no. My son got it in at Hollywood Studios in Disney World. They have a Star Wars bar, which it's cool. very, very Star Warsy, and they have drinks and cups, and it's a souvenir thing.
Oh, that's awesome.
Do
they have fog coming out of the drinks and stuff?
Some of them. I mean, this is a kid's drink, right? So it's one of those. But he didn't have any place for it, so he just kind of threw it back there. Yeah. So
Lola and Winnie, they're on their own schedules. One of them doesn't like to come in, right?
Winnie does not hang out in this particular room. It's not her style. She likes to hang out in her house, the couch, or the floor. But Lola comes in here, but she's not in here now, so she may wander in a few. You'll never know. You'll see her in the back. Sometimes she does that.
Question: defense can't cross rebuttal, right? Can they bring witnesses out after the rebuttal? Do you feel like it?
I mean, I guess they're not going to. There's nobody. I don't think there's anybody to rebut. I mean, it's at this point you're almost wondering why is the prosecution even doing it? I mean, what is Welcher going to say that's going to, given what he's already done, that's going to affect the credibility of the ARCA guys. And, this time the problem is when he comes in, they already know who he is. And there's a good chance they already don't like him. If you remember, his demeanor was on cross was pretty inappropriate for an expert. He wasn't all that impressive. They know about the paint and all that stuff. Now they'll listen to him, but he doesn't come in with a clean slate. I mean, they may very well be rolling their eyes and saying, "Oh, well, this guy again." You don't usually see that.
I call him a D. I'm trying not to be profane. Welch's emotional support laptop says, will either side ask Hartnett what she wanted to correct last time?
Well, it's not appropriate because she's there to rebut something offered by the defense. Now, do I think that Brennan and her have spoken? What was that all about? And it would be this? Yeah. If there's a way to get that out and it's favorable to him, do I think Brennan would do it? Of course. But in theory, she's there to, for a very narrow purpose.
So those excellent. You have any final thoughts tonight? That anything we didn't discuss over today, or even maybe the previous Friday too?
No, I mean it's ending soon, but I just think today was that was really underhanded what you saw, and to see a prosecutor do that on, in essence, national TV, everyone watching. And it's just everything about this investigation and prosecution. There are so many. How could they do this? I can't believe this. And I just, can't help but go back to when they issued their press statement when he first started, and he said, I'm paraphrasing, of course, but my central charge is to guarantee that Karen Reed gets a fair trial. And the only place that you feel like that's really true and they're trying to give her a fair trial is if she was, in Stalin's Soviet Union or something. What happened today is the exact opposite of a fair trial. All the stuff that he's trying to keep out and prevent her from introducing on her behalf is the exact opposite of a fair trial. So it just seems that, the public, yours, mine, and others' version of what a fair trial is must differ from what the people in the Norfolk DA think is a fair trial.
Another question for you tonight. Devers' testimony with the police commissioner, given that kind of sit-down meeting. Do you expect anything to happen about that? I'm surprised it's not more of a story in local media. I'm surprised they haven't made hay out of that one.
The only thing
especially with the election season too for the mayor.
The only thing I would expect to happen about it is they would pat her on the back. She did what she was supposed to do, right? She said that initially I thought it was the case, but I learned later after thinking about it and looking at stuff that it was a false memory. Everybody knows that she was called in as essentially a rookie and told, we got your back, do the right thing. And then everybody knows about her embarrassing demeanor. But from the perspective of the Boston police, at least the brass, she did what she was supposed to do. So I don't think it harms her in that regard. I just think she's harmed her general credibility, obviously, and her integrity. That testimony is available online for everyone to see basically forever. And I would hope that she regrets that. It's just embarrassing. Her demeanor is so. I think it's going to more affect her personally, just reflecting on, my God, you want to feel sorry for her in a way if you believe she was put up to this. if she was pressured and put in an impossible situation as a young police officer and all of that. But that doesn't compute with the tone and attitude, which was embarrassing. So, but I don't think it's going to affect her as far as her department is concerned.
Here is a good one. Sue says, what new testing could Welcher be doing? New paint? Maybe he's going to do a red paint this time.
I was going to say, I mean, we've had blue, we've had yellow. What's next? I don't know. You know, he's not going to be doing what you saw the ARCA guys doing, I don't believe. I don't know. Nothing he talked about, at least on his regular testimony, his original direct and cross, had any scientific component to it really at all. I mean, there was no physics discussion. There was no, and don't forget, he's already locked into saying, I did a 2 mile an hour, at this way because I had no information really. I don't know. We don't have enough information. So how can he do testing if he doesn't have enough information? And he's also locked into saying that unlike the ARCA witnesses, that he very much relied upon non-scientific evidence to help form his opinion, including Karen's interviews, the taillight pieces. I mean, look, he's saying I relied upon the taillight pieces as it's kind of like the cart before the horse, if you think about it.
Right.
According to him, the taillight pieces help show him there's an accident. But if he's going to rebut the ARCA guys are saying that taillight is there. It's not there naturally. Right? I mean, in essence, they're saying no impact. I'm paraphrasing. So how does he rebut that? I don't even know.
Yeah, it makes no sense. He's going to have to come up with something brand new.
He's not, I mean, but if he's going to rebut them, he's got to have like a scientific why the taillight would crash at the lesser speed, why the hoodie would have holes, in a different way. Is he in a position where he's even capable of explaining the diffuser problem?
No
I mean,
way.
The diffuser problem, that's kind of an underrated thing. It's kind of a two-headed monster for them. On the one hand, they claim the diffusers are destroyed in like 4 spots. They're not operable, basically. But in all the ARCA tests, discounting the last one where they went full speed 29, and they smashed into them so hard they blew out the windshield or the rear windshield. All the other tests, the diffusers were fine. And even in that test, they weren't nearly as damaged. And then you have these videos where you can see light diffused, which just means spread around, where if the diffuser is broken, light can't diffuse, which means you would just see like a little red dot in the corner where the actual LED light is. So, I don't know what Welcher's going to say about that.
He's going to come up with BS that doesn't make any sense. Not backed by science.
No.
This is the question that one of the questions I want to know. DJ Mom the Bomb says, how long do you think the deliberations will be? And what do you think it means? If let's say they get it on Thursday and we find out Friday morning that they have a jury verdict. Is that good for Karen, you think? And what happens if it goes a week like last time or 3 or 4 days?
So first of all, jury deliberations, we're not present. We don't know what's going on. We don't know how long they're going to be, all that. What I would suggest, if they got the case Thursday afternoon and came back quick, then I would say that that's almost certainly an acquittal. That strikes me as there's no way you're getting through all of this and talking 12 out of 12. Yeah, down she goes without much more debate. Again, I think they're in a much stronger position on the facts, the credibility, the way this is played out, the scientific evidence. I mean, if you're going to get to a guilty verdict, I think there's so much more to work through, and there's going to be debate before you get people there, that I would think a quick verdict would almost certainly favor the defense. Once it goes longer and longer, I mean, does that necessarily mean it favors the prosecution? Don't know. Sometimes there's someone you have to convince one way or the other. Sometimes, like the last trial, there's no agreement. I mean, you're really guessing what's going on, and you just don't know what they find important or don't. The only clue you'll ever get is perhaps the substance of some of the notes might at least key you in what they're thinking. But even that, sometimes you could have 10 or 11 jurors piling up on one, and the one doesn't want to break, and so they ask for a piece of evidence or an instruction to convince the one. So it doesn't even mean that, it's like, oh my God, they're freaking out over this. It could be, no, you're wrong. So
I get that one to change to
yeah.
to not guilty, for instance. That could be easily, I could see that.
You
and people think that everyone's thinking, that you never know, right? You never know unless you're in there.
You don't know what's going on. I will say, if you've ever seen 12 Angry Men,
It's a great movie.
Incredible cast. Great movie.
He's a great actor.
Great movie. Filmed inside 60 Center Street, which is the Manhattan Supreme Court. But I mean, the whole Henry Fonda and the rest of them, incredible movie.
It was. That's when I got Henry Fonda. Like, I was like, oh, that's why he's good. He's really good in that movie. He's the juror that's what we hopefully we don't need a guy like him there. Hopefully they all get it.
Yeah, I mean, I haven't been there, so I have no idea, I mean, what the jury is or isn't. All I've heard is that they're relatively young, at least as compared to the past, which, that's probably not a bad thing for the defense either, just in terms, again, that's a really wide, broad stroke, but young people, for example, might understand what signal is and not care. I mean, it's really kind of a nothing issue. Little things like that with technology.
Here's a question, Mark. Can you explain the deliberation process? Do they initially take a quick vote of guilty, not guilty for each charge, and then go from there, or do they piece by piece go through all the evidence?
They do it the way they want. I mean, the judge will tell them some guidance. The foreperson leads the discussion, although they have no authority. I mean, all they are supposed to be is the vessel between the court and the jury, deliver messages, that sort of thing. They're not supposed to, guard the door and play gatekeeper like we've heard in these horrible interviews that are frightening about how that allegedly happened the last time. They're not supposed to do that. I think most juries will probably take a quick straw vote and see where they are and then go from there. I mean, logically, you would go top down, obviously, and they'll be instructed about that to start with murder and go down. But in terms of how they actually go through it, in terms of evidence or witness by witness, it's kind of a free-for-all. It's kind of, there are no rules other than they get told, be fair, listen to everyone's views, be firm in your principles, but be willing to change if appropriate. The boilerplate lecture about be open-minded, but don't roll over either.
Music to My Soul says, Mark, do you think the defense has done enough to get a non-guilty on the lesser included charges this time? Obviously, that's the only thing the jury really hung on last time.
Yeah, I mean, look, again, the jury will decide, but I think it's an acquittal across the board because I don't think they've established a car accident beyond a reasonable doubt that caused death. I mean, I don't see it. If there's no car accident beyond a reasonable doubt, there's no crime proven beyond a reasonable doubt. So that's what I see. They still have this witness, La Posada, who's going to give them some help. Obviously, Rentschler, I think, is going to be it's no secret why at this point They want Rentschler to be last. And, again, primacy, recency, and jurors, even when you're dealing with experts, they like easy facts that they can remember, such as the videos that you've seen about the arm getting smashed repeatedly and bending and contorting. And then also you hear from Rentschler, who basically says, you would expect bruising, broken bones. Those are facts that I think any juror can understand. And they have their own common sense. There are experts, but you sit in the jury room and say, how could there be no real injuries to his arm? And I'm talking, again, bruising and bones, not these cuts that are visible on his arm, which are not consistent with a car accident by a lot of the evidence. And I think that common sense point, being the last thing the jury knows fact-wise, is going to be very powerful, because it just seems like such a common sense, obvious thing without a burden of proof. I mean, that's a good position to be in.
Just about wrapping it up, but I did give, I saw Flip Ahead was in the chat. I just sent him a link.
Pull him up.
I always said we got to have him up for a couple minutes at least. I want to try to get to the JFK party tonight. He's having a party tonight with James from 7 to 10. So I'm hoping to jump over there real quick too. Here's another question while we're waiting for Flip Ahead and about to wrap it up too with Mark. Leona says, do you think Bev is intentionally interrupting the defense motions when they're arguing them as a possible way to throw them off? She seems to do that a lot. What do you think, Mark? Is there any, is she doing it on purpose or not?
Look, I can't believe that a judge is literally fixing outcomes or manipulating the possibility of an outcome, like Tim Donaghy. Remember the NBA referee who was actually indicted in federal court in New York probably 20 years ago now for gambling debts, and he was calling fouls to manipulate the outcome of NBA games to fit spreads because he was I can't, whatever the appearance is, whatever seems to be really bad rulings, I don't think she is literally doing that. Send all the criticism you want. That's too much for me.
I like this. It's funny. We have this question about the third party. Let me get this up because I think they kind of answer the question for themselves if they think about it. Bonnie says, how did the jury determine how John died if they haven't brought up the third party culprit?
Well, I think that's the whole point, is the defense doesn't have to prove how John died, and there's no evidence beyond a reasonable doubt how John died. So although we'd all like to know, this is not the exercise in the forum for that. What the defense ought to say is, we don't know how John O'Keefe died, but what we do know is, based on the evidence, wasn't her sitting at the table over there. But it would be a mistake to start, to use the clue analogy again, to start with was Professor Plum with the candlestick in the study, which is the same thing as saying, it was Higgins in the basement with the weight bench. No need for that.
No need for that. I love that you said that. That was one of my grandfather's big phrases. No need of it. No need of that. No need of it. He used to always say that one. Yeah. I hear you in my grandfather. Joe Flipahead's too good for us now. He says, I can't go live right now. I want a full show with Bunk. I don't know if you're going to have much time. This trial's ending. Like, how many more shows are going to get here, Joe? He's too good for us tonight. He wants a full. He doesn't want 5 minutes. He wants 2 hours with you, Bunk.
Well, we could talk about The Wire, and all that kind of stuff for hours, I'm sure.
That's true. After the trial, there'll be like plenty of time. Maybe we'll do a full hour or 2 hours discussing The Wire with Joe Flipahead and Mark Bederow. That would be something.
Yeah, no, I maybe there's a Wire rewatch in the cards in the near future. It's been a while.
Let's a few more questions came in. I think we'll, oh man, I every time I try to click on one of these, they move so fast. Here it is. Mark, do you not think there are bad doctors, teachers, bankers, etc.? Why can't a judge be the same? Or did I misunderstand you? I think that's been your whole point the whole time is that you
Um,
wanted to give her the benefit of the doubt that she's bad at her job, not corrupt, right? I mean, generally.
I'm not going to sit here and literally say the judge is corrupt. Okay. I think in this case, and I think I said it tonight pretty clearly, actually,
You did.
that she's made a lot of rulings I don't agree with. I think she's been hypercritical of the defense unfairly. I think that she has allowed things that shouldn't happen. I think she's given Brennan a pass. I think she hasn't ruled favorably on many, many things for the defense. I think her tone to the defense has been improper at times. I think her rulings on objections have been both skewed against the defense, and the editorializing on some of them have been not judicious. And I think I just said that if there was a third trial, they should move to recuse the judge for having an appearance of bias. Whether she is literally corrupt, I'm not going to sit here and dive into whether,
I gotta say too, you also have a client that's in Norfolk County facing charges. It's
but,
probably not the best thing for a lawyer to say about a judge in that courtroom, right? I mean, just say it.
But you also have to understand, like, there are many judges, like where I come from, you think of certain judges differently. Some are much better for you, some are much worse, some drive you crazy, some don't. You try to resist the idea that they're literally in the tank. Now, if some people think that, that's fine. Okay. That's just a bridge too far for me. I've been critical. I don't think this case has been adjudicated so great, but it really shouldn't matter whether, I use the C word or not. There's no need.
I agree because I feel like I want to say it a lot too. Like I feel like she's corrupt, but it's like, how do you know? Like, how do you definitely know it's that and not something else? Someone says Bederow's book club. Bederow's book club. Maybe that people want to have a Bederow book club.
Stuff back here. Yeah. You know what? Most of this stuff back here, I'd say about 80% of that front row is all books on Winston Churchill and other World War II stuff. And most of the stuff on the bottom is a lot of Abraham Lincoln Civil War stuff and David McCullough books. Yeah.
Oh, David. Yeah, I know David. Big historian.
Yeah. And then the books in the corner right here is actually the whole original Ian Fleming James Bond series.
Oh, wow.
Yeah.
Is that like a collector's item type deal, or is that like a reprint? What do you think?
Well, it's a collector's item if you define Barnes and Noble 2008 reprint. No, they're not originals.
They're not yet, but that's pretty cool though. Still.
Yeah. No,
Ian
got multiple bookshelves all over the place. I'm a pretty big reader.
I used to be a big reader, but yeah. It's funny now the internet. In this case, I mean, I think I read sometimes as court filings.
Yeah,
to be honest,
not as much as it used to be because all the streaming stuff and all that.
I used to be that kid. My mom, and I was kind of a jock kid, but I played with a lot of the neighborhood games, Sandlot, baseball, that stuff. But back in the day, like when I was in second and third grade, my mother used to I'd be like on the porch or under my bed reading books so much that my mother would kick me out of the house. She'd be like, "Oh, go play with your friends. Stop reading. You're reading too much."
Yeah,
I mean, that's funny. It's like, most parents probably wish their kids did read, right? I mean,
reading is good. Yeah,
it is good. Saved me. Who knows? I had enough problems. If I didn't have reading, who knows what would have happened to me? I was a mess.
Keeps the mind sharp, improves vocabulary. It's good.
Brings you to new places too. It's like traveling without actually traveling, So if you're in the ghetto or in the worst environment, you can still travel. I love that about books and movies too, and music. Here's a comment that came up I want to bring up tonight because I think I've seen a lot of this tonight. ex-FBI is the one attacking his family, talking about Dr. Wolf. I mean, how ironic is that? The people who've been throwing the most shit around are the ones attacking Dr. Wolf right now.
I did see that. I did see, the ex-agent.
Yeah.
Is it technically witness harassment? I don't know. It's just pathetic. She's out there for clicks. We know her shtick. She states things that are not based in fact. She just states not, takes about this proves that. She offers no analysis. And I think she read something. What did she do? Where she said the defense, she meant to write the defense was conceding a point, and she said they were seceding, as if they were, I don't know.
Seceding from the union.
They're going to leave the courtroom. They've quit the proceeding. They're seceding a point, and I don't know what to make of her. She just ignore her. It's hard, I know, because some of these tweets are confounding.
We do. It's funny. Like I said the other day, the only one I still check in on every once in a while is Kevin. It's because he makes me laugh. I don't know what it is about that guy. He just gives me the laughter.
I don't know why an ex-law enforcement person like her would be flat out accusing Dr. Wolf of lying and this and that. And it's just embarrassing. And
especially going after the wife. It's like, you're going after the wife? Are you kidding me?
Yeah, I mean, in general, look, there's too much family stuff all over the place. Generally, I think it would all be better if everybody left out everybody's wives, kids, husbands, and it's.
I don't do any of that. I don't go after anyone's family, their kids. If I have a problem with you, it's about you. It's not about your kids or if you're relevant. That's just, I don't get it. I don't get that at all.
Yeah.
I keep saying we're gonna have one more, and then we ask one more. I will ask this one. Actually, did I ask this one? I think I did. I think we pretty much got them all tonight. A lot of these questions we've already kind of asked. It's just different variations of them. So I think we've gotten to. Well, here's one. Tell us about prosecutorial misconduct. When a prosecutor does misconduct, what does that entail, I guess?
That's a broad term. It can entail many things. Sure as hell includes if you intentionally or recklessly offer false evidence or create a deliberately false impression in the minds of the jury on a critical fact. Like today, that could absolutely be prosecutorial misconduct, suppressing evidence, suborning perjury. Many, many things can be prosecutorial misconduct. Certainly, in my view, what you saw today with Brennan in the hoodie is a textbook example of it.
What do you think? Is this too much? If Alessi would have said, "Where's your grave concern, Your Honor"?
No, I kind of agree with that. I think the more smarter way for the lawyer to do it, just because of the pushback, would be reminding the judge that you have found, and I quote, grave concern over this, and then say, if you found that to be of grave concern, certainly these circumstances, which are 1,000 times worse, must be, double secret grave concern, right? Like double secret probation. This is, the stuff that happened today is so much worse than, the stuff that he was alleging pre-trial that raised grave concerns and had the court really smearing the integrity of the lawyers and taking them to the carpet, getting news stories about it. And today, she didn't say anything to give any indication that she was the least bit concerned about any of this, which is just shocking as hell to me, because your jury could have been poisoned and misled on something very significant. And if that was done on purpose, which again, to me, I think it's pretty clear, and I think the most sensible people is pretty clear, that's outrageous, and that ought to be punished, and punished severely. And they sought the ultimate punishment, which is a mistrial.
Do you think Alan Jackson will ever try another case in Massachusetts? Defend another case.
I don't know. Probably, if he has a choice, not in Norfolk County in that courtroom. But I mean, who am I to speak for whether he'll? I don't know.
I mean, this is probably, I know at least his second case because he had that other case with Kevin Spacey. So I wouldn't be surprised. His name's very well known in Massachusetts now. I want to thank you for being here again with us, Mark, attorney, Mr. Bederow, to you. And thank you so much for being here. Almost 2 hours. I don't, anything else that?
No.
I think we got it all.
Yeah.
Someone's going to ask me, say that I missed one of their questions. One question that's going to be coming up, this will be, I think, the final one, is apparently the transcripts from the first trial were never released. Not the transcripts, the sidebar discussions. Is that unusual? It seems like they would have those sidebars out. Is it because this is a retrial? Like, why would they not put out those sidebar discussions from the first trial?
Parties have the sidebar transcripts.
They do? Okay. So they have them, but will the public ever get them?
Unless there is something that ought to be sealed and not unsealed. Court proceedings are presumed to be open. So I'm not sure why they wouldn't be subject to certain redactions if something, again, that fits under the statute for sealing something. I mean, if you were talking about like a cooperating witness or something like that, but there is no basis to keep just because it happens a sidebar when it's over. The reality is in most trials, a lot of the stuff that you saw at sidebar would not happen at sidebar. They would just kick the jury out and argue in open court. And there ought to be a presumption of openness. And I think that's another kind of concern about what you're seeing in this case is that there's just so much that's done outside the public's knowledge on a case that has incredible public interest. And that, that's generally not how it's supposed to be done.
Said last question about lying. Can they say they need missing witness decision before they close? And if she says no to instruction, then can they call Proctor or Higgins? They have to know before they close, right?
Yeah, the charge conference is right before summation. You have to know because you have to know what you can do and not do in summation. Because if you get a missing witness charge, they're going to clobber them over the head in summation with it. But they won't know until the charge conference, which is when the evidence is closed. So you can't hedge and then say, okay, well, now I want to call Higgins. It'll be too late. You will have rested. So they will not know at the time that they rest whether they're going to get a missing witness charge. They'll know at the charge conference right before the summations.
Excellent. I appreciate it. I just saw a more of Alessi, one of my favorite folks on here, said I missed his question. You gotta post it again. I can't look through the chat. There's too many comments. I'm sorry I missed it. But I appreciate you. I want to thank Attorney Bederow for being here, Mark. Thank you so much for your time. You got any upcoming shows coming up? Anything announced?
No, not that I'm aware of. Nope.
So maybe you'll be here back tomorrow night, hopefully. We'll see. We'll see. I want to thank you again for being here, and it's always a pleasure, and we'll be watching from court tomorrow. Thank you so much, Mark, for being here again tonight.
All right. Talk to you later. Bye.
Bye now. And you can follow him at Bederow Law. He's got a website, BederowLaw.com, and at Bederow Law on X. Please do follow him. I want to thank everyone who sent in your questions tonight, your comments, your super chats, and all that. Thank you, Laura. She says we all patted the curse jar today. I know, right? It's hard not to be a little bit upset today watching that go on. Thanks, Bev's bias beratements and rulings. They said I think that's €2. Said, love you, Mike. Buy yourself a coffee. I will. I love coffee. I'm like Bederow. I'm the same thing as Bederow. 2 cups in the morning. That's my peak. Well, I mean, that is I have a little deck here. That's what I do. I get up early. I don't do anything. I have well, actually, I take out my boy Charlie first. Then I sit down, drink my coffee, and I don't do anything. I sit on the porch and I just kind of check it, especially if it's a nice day like it's been lately, to get those nice mornings. My 2 cups of coffee. Thank you so much. I will be drinking some extra coffee this week on you. Maria Tanya, thank you so much. Says the 19 super sticker. Thank you so much. Jennifer sent 4.99. Says watch Canone cover her mouth talking to herself right before Lepisoda took the stand. Camera caught her and she freaks. I know we all saw that. That was it's on X. It's all over Twitter if people want to see that. Thank you, Jennifer. We did mention that tonight. Slinky underscore 2021 sent $2. Anywhere we can go to see corrective oversight. I don't think so, man. Unfortunately. Doesn't seem in the cards. KNS at 4.99 says, love the way you make these legal matters accessible to those like me with 0 days of law school. My 2 cents is explain it to the jury like this. I know that's what's so great about Bederow. He knows his stuff and he knows how to just sound very eloquent, but the common person can understand what he's saying. It's a skill. See why he's a trial lawyer. Very good at this. Brenda asks that's my biggest disappointment, honestly, is that we didn't get to see him in the defense. Brenda S sent $15. Said, did grand jury duty for month of 9, 2011. It does something to you to be faced with the most evil of society day after day, all damn day. Prayers up for jurors and justice warriors. Thank you, Brenda. So I'm wondering when you say that, Brenda, if you're talking about the most evil of society. I'm guessing you're talking about the person that was on trial and not the prosecution. But you never know. I'd love to hear more about that, Brenda. What kind of trial it was. I've had some friends on jury trials, and it definitely does change them. I had one interesting friend who was on a jury trial when we were younger, and he's kind of a person that I would expect to like convict everybody. Like he's just that type of person. I'm not going to even say who it is, but he's a good guy. But I just knowing him, I expected him to convict whoever they put in front of him, and it was a not guilty. And he basically, when we talked about it after, he said, looking at the guy, I think he probably did it. But the facts of it, the case, the state didn't prove it. The state didn't present any evidence to show that he actually did the crime. So he found not guilty, and the entire jury did as well. So hopefully that happens this time with Karen Reed too. Whether you think she's guilty or not, the state didn't do the burden. They didn't present enough proof to prove that she actually did it. I think a lot of people who get caught up in this case, the simpletons that just, oh, she's guilty, not the ones that are, dishonest that I was talking about earlier, the ones that hope the simpletons are on the jury and fall for it. But there are simpletons out there, and I just think they have to realize that the state did not prove she did it. The medical examiner, number one, you have no cause of death. Come on. Let me read a couple more of these super chats. And if anyone's interested, James and JFK are doing an event tonight from 7 to 10 in Lynn. I think I'm going to head over there. I'm hoping to get over there in time. If you want to check that out tonight, they're doing a live meet and greet. Jack Butson says, thoughts on if the holes in back of sweatshirt might have been one of Welch's rebuttal points. I have no idea. I mean, how could it be at this point, right? Kristen Galante says, if it goes to appellate court, is Alan Dershowitz being looked at for taking the case? I don't think they're thinking about who's going to take the case for appellate at this point. I think they're thinking we're going to get a non-guilty verdict. But who knows? I have no idea. I just have a feeling they're not really thinking about who's going to be for that, because they want a non-guilty finding. Angel says how the evidence got to the witness stand without the judge or the defense knowing that he was going to use that piece of evidence exactly. I don't think he told them. I mean, I think that's the point, Angel. He kept it a secret, right? Like Bederow said, he didn't bring it up all those other times. All those other times he could have brought it up, but he didn't. He waited till the very end to slip it in when it mattered the most, right? This guy, it wasn't an accident. He knew not to bring that up earlier, I'm guessing. And again, I think it shows intent. Catherine Carroll sent 20 and she said, so fed up with Brennan and Bev. I just can't understand how this case has gotten this far. Makes me sick. Who is the governing agency for this? Ghosted Mr. Higgins says Garrett Wing should be testifying. I agree, but I think Bederow made some good points tonight on it. He made some very good points on it. You know, you've got Dr. Russell already in there, medical doctor. Why chance having it be all about Garrett Wing, right? You know, Brennan's going to attack his credibility. He's not a medical doctor. Why have the jury think about that at the end when they already have Dr. Russell? It's almost like quit while you're ahead, you know? It's strategy. I mean, it's, yeah, quit while you're ahead. I've seen so many wrestlers. So not so many, but in the past, you'd see a guy up winning like 12-0, and all he's got to do is like stall for 10 seconds, and he goes for like a headlock and a pin, and he gets rolled, and he gets pinned and loses the match. Like, quit while you're ahead. You know, sometimes you should quit while you're ahead. That's something you'd usually see in like middle school, high school wrestling, and college wrestling. You don't see that because the guys are smart enough to stall it out if they're winning 14-0. They're just like, I'm just going to take this big win. I'm not going to chance getting pinned at the last second. Usually the college matches in USA wrestling stuff, it's like the matches are like 3-2. You know, they're so close. No one can score against each other. They're just too good. We did talk about this tonight, YouTube, Ev. If you missed it, you can definitely go listen back. You wanted us to talk about the role of the PI they had. We did talk about that, about the measurements and about the stairs in the house and how Bev Canone wouldn't let that in. Rachel sent $1.99, says, any advice for us schmucks in Norfolk County? Vote. Get registered to vote and get ready to vote for DA and campaign. Campaign for, there's going to be two candidates running against DA Morrissey. Start supporting them. Get their signs. Reach out to them. Find out how you can help them. Show up when they show up in your town. They're going to be at certain functions. They have like town Democratic clubs and things like that. So volunteer to help them. There's two different campaigns. I would support them both. I think that's one of the big ways you can help is get involved in your local town, your local elections, and especially for this DA's race that's going to be happening next year, November. We're about a year away now. Now it's June 9th. So we're about little more than a year, little less than a year and a half. So like a year and a half from now, November 2026, there's going to be an election. And I think the primary's probably in August, actually. So it's just a little more than a year, I think, on the primary. So I would say get involved in that DA's race. Reach out to those campaigns. Join their email list, so that you know when they're having campaign events and you can show up and help them, maybe support them, maybe send them a donation. Mary Hughes sent $1.99. Thank you so much, Mary. Angel said, how did the evidence get to the witness stand without asking the judge in open court? Can Mr. Bederow answer this? I think we kind of did answer that, but from now on, ask the question for free. In this, we don't ask Bederow questions via super chat. Mary Hughes says the system was truly just when the prosecution evaluate the reasonableness and truth of the defense instead of arguing against it. I think that's a great point. Thank you, Mary. Oh, there's one I wanted to acknowledge. Did I lose that one? Oh, here it is. I got to make sure I acknowledge this one. Tiff says, I'm sorry, Tiff. I didn't mean to imply anything. She says, Mike, I'm going to strike and ask you guys to disregard Mike's comment about which side I am on. I want to make the record clear that I am free Karen Reed every day of the week. Oh, thank you, Tiff. I'm glad that we could clear that up for everybody. I'm sorry. I implied you might be anti Karen Reed. I didn't know. I thought you were free Karen Reed, actually. But some people have been, you see them as free Karen Reed, and all of a sudden they start acting weird. We noticed that in the last week, a few people. So who knows, right? I didn't know. I wasn't meaning to imply that. It was just a curious question you asked. I thought it was a good question, actually. Thank you, Tiff. I'm glad that you're free Karen Reed. I'm sorry. I think everyone knows that. Thank you, Tiff. I want to thank Bill. I'm sorry, screwing up now. Nate, I want to thank Mesa's Nana and Bree Lawrence. Thank you, Bree Lawrence, for becoming YouTube members tonight. And also the McReb. Is that like the McRib? The McReb. The McReb became a YouTube member tonight. Thank you so much. I want to thank Amor of Alessi for the super sticker. Thank you, Esther Clovis, set 9.99. Fellow lawyer here. Why do you think that the defense has not filed any interlocutory appeals? What's the process for doing so in a criminal proceeding? We did kind of answer that question today. I think Bederow doesn't have any faith in it, you know, and it's like more work to do that. And if you don't think there's any hope of it, got to kind of focus on what you think is the best bang for your buck, PG says, "Do you think there is corruption here, Mike? Scale of 1 to 100, and why?" Oh, yes, 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 I do. I mean, I can't ignore it. I think, yeah, yeah, I do. I mean, I don't know 1 to 100. I would say 100, off the charts. I think there is corruption. I do. But do I know it? In my heart, I do. Do I think the election for Morrissey would be fixed? No. Madeline Wags actually asked, do I think the election? No. I do not think the election will be fixed. I think it will be decided by people voting in Massachusetts. And I question whether he's actually going to even run for reelection. There's a good chance he may not. The thing is, he's got like a lot of money in the bank. Like, I think it's like a $500,000. He's been uncontested year after year. He's got a machine. Even with all this baggage, it's possible he could win re-election. That's how much of a lock he's had on Norfolk County, and how many favors he's done for a lot of people who voted in the past. So the key is high turnout. If there's a high turnout election, he's losing. If a lot of people come out and vote for the first time, or maybe the first time in a long time, then he loses. If people stay home and it's only the hacks that are friends of Morrissey come out, he could win a re-election, absolutely. And I don't think it's fixed, no. So I think people need to get organized and make sure they get the word out. And they support those two campaigns. There's two qualified candidates. I really hope it ends up being one, because I don't want to see it get divided in a three-way race that usually favors the incumbent. So I actually hope one of them actually decides to drop out. We'll see. I don't know who's going to be the stronger campaign. I support them both. I think they're both good campaigns. I've interviewed one of them twice. I hope to interview the other one as well. They're both, former prosecutors. So we've got two good candidates. Project Com says, could this be a form of equity, kneecapping what he sees as too advanced a defense as a former public defender who never felt she had resources? Huh. Huh. You may have a point there. She could have some sour grapes like that. I don't know what her beef is. I don't get it. I don't get it. For me, I mean, you may have a point. That could be very well what's going on here, Project Calm. But for me, I feel like she somehow has some loyalty to Michael Morrissey. That would be my guess. Being that I believe she's from the Quincy area, I just have a feeling she's connected. Yeah, Mary, this is one of the greatest points around right here. This is what drives me crazy about this prosecution. All right, I think I got all the super chats done tonight. Thank you so much for the super chats tonight. But I'm feeling. I gotta say, I'm feeling good. I know we can all feel sick about what we saw in court today, but think about this. Despite all of this against her, I still feel like she's going to be found not guilty. I do. And I'm feeling more confident about it. And I know how mostly defendants never get a not guilty plea. So I'm feeling really good about this right now. I do. I think that the jury is picking up on it. When she said that today, I think that's a tell. She said the jury seems fed up. Who are they fed up with? Do you think they're actually fed up with the defense? I don't think so. I think they're fed up with the prosecutor and the judge. I could be wrong, but that's the feeling I get, and that I think the defense is feeling that too, and that's why they're not bringing out all these experts and all these witnesses. They don't need them. I feel like they felt like this last time, and people could say they closed. They should have gone longer. I felt like that. I really felt like they should have brought more witnesses out last time for the defense. But in a way, they were right. They got the hung jury. A hung jury is a win. They didn't know which way it was going to go, but they felt confident that they weren't going to get a guilty verdict. And I feel like they think this probably the same thing this time. They're thinking it's either going to be a hung jury or not guilty. So why push it? Why not just take what you have right now, which is a win? I have a feeling they feel like that. I got a $50 cash app tonight from eShell, and they said that they are sending a longer note through LinkedIn. I'll check that out tonight. Thank you so much, eShell. I haven't been on LinkedIn in a while. We do stream on there, but I never check it out. It's so funny, and I will check that out tonight. I'll have to log in there. Same with Twitch. I never log in on Twitch, and it's funny on LinkedIn. I have no idea how many people are watching us because it doesn't show you on StreamYard, even though we're broadcasting there. On Twitch, it does actually show us how many people are watching, and we have been getting like a regular 1, 2, 3 viewers, which is shocking because it used to be one viewer every once in a while. So we're actually growing a little bit on Twitch even. I'm going to have to log into both of those. Thank you so much for the Cash App tonight. Paula K sent $10 tonight. She said, "So happy you read my question about Dr. Wolf saying twice that the sweatshirt had cuts before Brennan held up the hidden sweatshirt. Loved hearing Attorney Bederow's reply. Thank you, transcripts, baby." Thank you so much, Paula K. And William also sent $50 earlier today. William B. And he says, "Thank you. Watch you the most." Thank you so much, William B. That was very generous of you earlier today. That was during testimony today. All right, I think that's it. I think I'm done tonight. What time is it? 8:42. I'm gonna suggest how many people we got so far. We still got 8,000 people. Wow. Um, you know who's live right now is Brian from LTL. He's got a live show right now, and he's doing it with Nan Gallagher and my friend Todd, who's a former state police. So what I'm gonna try to do right now, let's get this going. Hold on. I'm gonna redirect you. I'm going to redirect you over there and we can watch it together because I think that's a good show for everybody to watch tonight. I want to hear what Nan has to say and the retired state police, Todd McGee, and Brian from LTL. So I'm going to redirect you right now. I'm setting that up. Just give me a minute here and we'll all go over there and watch LTL tonight and tell them I sent you. There it is. Is that the one? Um, yeah, that's happening right now. So we're gonna do that. We'll watch it together. We're gonna do a Jerks raid on LTL right now. And again, I want to thank Attorney Mark Bederow. I want to thank our moderators. Thank you so much. I know some of them had it. Sarah and Shock and Horror is like, I need the night off. I can't deal with this tonight. So I want to thank Sarah. I want to thank Jeno. I saw Stephanie tonight. Scott McGinnis. MJ. I saw M posting some links up. Thank you so much, MJ. Thank you to all our moderators. If they need time off, take all the time you need. I get it. Believe me, I do. Got a couple more super chats came in. I don't even know what this one is. R1090. Anna Christina says, hope no one gets to be defended by Hank Brennan, tried by Bev. I know, right? And Donnie B sent $5. She says, with all the injustice throughout this trial, I'm honestly thinking that if Karen Reed is found guilty, there will be rioting in the streets. I hope not. But I don't know how people would react if she was found guilty. I think she'd have a lot of money in her canteen, I'll tell you that. I don't think it's going to happen. I don't think it's going to happen, Donnie. I think not guilty. Either that or hung jury. All right, I'll see you tomorrow morning. We'll be in court. Actually, I'll see you in the LTL chat. We'll be watching the LTL show, LTL Media with Nan Gallagher. They're live right now. I'll be in the chat, and then I think I'm gonna head over to see JFK and James over in Lynn at their little meet and greet. If you're over there, I'd like to say hi to you tonight. And if not, I'll see you also tomorrow morning in the court chat. We'll be streaming live tomorrow morning from court. Thank you so much, all of you, for being here. Thank you. Thank you, Jerks. We'll see you later in LTL stream, and then in court tomorrow morning. Have a great night, everyone. Thank you so much, Attorney Mark Bederow.